then the justice, in fair round belly with good capon lined, with eyes severe and beard of formal cut, full of wise saws and modern instances. And so he plays his part.
And with that, welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We are recording this on Tuesday, December 16th, go out on the 19th, 2025. But those first few words were not for me. They were from a special guest who we have brought on for a little Christmas pantomime for all of you, a little holiday special here. And that was our first assistant director at the Institute for Justice Clinic at the University of Chicago, James Joseph. So James these days is a partner at Eimer in Chicago. He has been our local counsel on numerous cases in the city of Chicago and the great state of Illinois when we have practiced there. And I was in Chicago recently, and James and I had coffee, and he reminded me that he has a theater background. And we started talking about theater and the law. And you don't have to have watched too much TV to know that there are some commonalities between acting and being a lawyer. And so we thought, that would be interesting to talk about. And I also wanted to get him on the podcast sometime. And so here we are. So, dear listeners, we are going to do a normal short circuit with cases and all that stuff. We're going to have a couple cases from the Third Circuit. They have crazy facts, constitutional stuff going on. So stay tuned for that. But first, if you will indulge us, we're going to do a little theater talk about how theater and the law relate to each other, which you all might be interested in, especially in this holiday season. So we have James, and then we also have our Deputy Director of Litigation, Bob McNamara, who, most of you probably don't know, has a theater background himself. He said he wasted a lot of time in law school. Instead of studying, he would be helping out with theater off Broadway. So
I never said wasted.
Not in our eyes, Bob. Not in our eyes. So we are going to start with James with his some of his background and on this topic of theater and the law. We'll go from there, and then in a little bit we'll get to the cases. So James, welcome to Short Circuit. Thank you so much for coming on. And if you could tell us what you think theater and the law have to do with each other.
Thanks, Anthony. Thanks for having me. It's a delight to be here. As you know, as you mentioned, I've had a longstanding relationship with IJ, and it's an amazing organization. So I'm glad to be part of this. I have a long history of theater because my mother was a huge theater aficionado. And when I and my sister were little kids, she sent us off to theater camp. So that was one of the first kinds of things we did when we were little. And so I always kind of had some connection to it. I didn't study it. It wasn't my major in college, but I did study it there. And then after going to law school and practicing law for a little bit, I thought, I'd like to do this a little more actively. I miss it. And so I took a little time off and became a professional theater actor in Chicago. Eventually, I was able to reintegrate with legal practice, including, as you mentioned, at the IJ clinic. But I have been a stage theater and actor in Chicago for 25 years, from Tony-winning theaters to small storefronts, from Shakespeare to new plays, and it was a wonderful way to enrich my life.
I lived in Chicago from 2005 to 2009, so that would have been before. I'm sure it was before I met you, but we used to go to the theater a lot back in the pre-kid days, and I probably saw you on stage a couple times without even knowing it. So, what do you see as commonalities? I mean, when you're talking to a jury, of course, you can see how an acting background would perhaps come in handy. Is that what you're thinking of, or is there even more to it?
I think the stereotype is kind of that. You stand in front of an audience and you orate and you enunciate and you gesture and you are passionate. And I actually don't think that's, there's some truth to that, obviously, but that's not really what it's about. I think that the benefit of being or having some stage training is much more nuanced than that. The most critical thing I think it teaches you how to do is to be honest, to connect with something that's honest in yourself, and connect with other people, because the best actors are the ones we think are the most natural, right? If you win the lottery and you jump up and down screaming, that's a natural reaction. And the best actor would be one who could make you think that they had just won the lottery rather than, presenting it in some way. And particularly in litigation, I don't know how it would work in other circumstances, but particularly in litigation, you're an advocate, you're trying to persuade people. And the best way to persuade people is to connect with them on a human level. And so to the extent that you can do that, you have advanced your cause. I do think there's some other important, again, sort of nuanced things that can be brought to bear. One, I think, is the importance of storytelling and story structure, understanding, the different ways that stories can be put together to be compelling, and
Right.
how the story has to vary depending on what the circumstances are, and figuring out who the cast of characters is. I have often organized my cases with a cast of characters, because, just as such, not, these are the witnesses, but this is the cast of characters, because it makes for an interesting story. And you always can tell, again, in sort of building these connections, you can always tell whether somebody's thought about these things because of the way they approach the witnesses. We tend to, in legal cases, it's very easy to get abstract. We see names in a case report and we think, this is just the plaintiff and that's the defendant, but no, they're real people and they have backgrounds and contexts, and there's a jury there and there's a room and lighting and all of those things you have to think about, in terms of how all of this came to be. And that's kind of the last point, which is that there is some production value to all this, right? So when you are, it's not just standing in front of people and orating, but you have to think about entrances, exits, timing, attention spans,
A good opening.
a good opening, right? A good closing, primacy, recency, all of these kind of soft psychological factors that come to play, again, sort of wrapped up in story structure, but also production value, making sure that things aren't done on the fly, or if they are, that's purposeful. Sometimes, if you go in front of a jury and you look too polished, that can be a problem, right? So there are all these sort of subtle production value components that play into it too.
Bob, tell us a little bit about your background. Also, maybe keep going where James was, but also how this all relates to public interest law specifically, because I think of so much that we do at IJ really resonates with what James was just describing.
Oh, absolutely. I mean, I grew up in the theater. I was never a professional actor. I have been paid to do theater intermittently, but never enough to, eat food. But I really, until I came to IJ and decided I needed to kind of devote myself to my profession and devote myself to really the work we do at IJ, I spent an inordinate amount of time on stage, backstage, directing, stage managing. And everything James said is right. The theater really is great training in telling stories to small groups of people. And at least in litigation, a lot of lawyering is telling stories to small groups of people. And I have traded on my theatrical training at IJ as much or more than I've traded on anything I actually learned in the law school part of law school. The stereotype is that, theatrical training helps in the trial court because trials are little mini plays and you have to think of them as how you're presenting it to the audience and who the characters are. And that's true. And James is right that it's not bombast. Like, bombast doesn't work. Yelling at people doesn't work. And it doesn't work in the theater either. That a lot of the moments I think of that I really noticed in the moment that I was trading on my theater background are very small moments where I just understood attention. Like I was on trial maybe 10 years ago, cross-examining the mayor of this city. And the mayor, it became instantly obvious that the mayor's plan was to filibuster my cross-examination. I'd ask him a question and he would give a speech because he was a politician. And this was a judge who did not allow you to interrupt the witnesses. Some judges with, a really unruly witness will let you break in and say, that wasn't my question. This judge, hard and fast, the witness was going to talk until he stopped talking. And so what I did was maybe the second or third question when he started his speech, I left. I left the lectern and I walked back to counsel table, and every federal courthouse in America has the same little jugs of water, and I poured myself a cup of water, and I wasn't ostentatious about it, but I've been doing this enough. I know how to make you look at me instead of look at someone else. And I got my water and I kind of moseyed back to the lectern and I timed it. So as soon as I got back to the lectern, I said, so that was a no? And everybody in the courtroom knew what I was doing. They knew what the mayor was trying to do. They knew what I was doing. And it just diffused his entire thing because I've spent a lot of time thinking about whether people are watching me or watching something else. But it's more than that. I think what kind of live theater training teaches you is an ability to be present in the moment. And I've advised several young lawyers who have trouble with appellate arguments, not just trial work, that I think people who struggle with appellate oral arguments sometimes have difficulty really intently listening to what someone else is saying, while also allowing part of their brain to figure out how to respond and how what this person is saying fits into what you're going to do next. And that is very specifically the skill of improv comedy. And appellate advocacy is, I always tell people, no one believes me, but a good appellate advocate is a good improvisational comedian.
Oh, absolutely.
They're good at listening to what you're saying, incorporating what you're saying and what you're thinking into sort of what they already have going on and responding fluidly to it. And so I don't think I would be nearly as effective a public interest advocate if I didn't have, years of live theatrical training under my belt, because it is all about how you command attention and tell stories and talk to people in these small groups that just happen to be in courthouses rather than in black box theaters.
Yeah, Bob's exactly right. The irony of being a good speaker is that you are a better speaker when you're a good listener. And I can tell you that both on stage and in the courtroom, when I forgot about how I was doing and what I was doing, and I just listened to the other person talking and absorbed what they were saying and responded it and had confidence that I knew what I was talking about anyway, you actually speak more articulately and cogently because you're responding to the person you're talking to and you're connecting with them, and it makes a huge difference. I will say that one thing being an actor doesn't help with is stage fright. If you have stage fright as an actor, you're going to have stage fright as a lawyer. And if you don't have stage fright as an actor, you won't have stage fright as a lawyer. It's the same. The key in both professions is the same: prepare.
I mean, even the best appellate advocates say they still get stage fright before they go on that lectern. But
right.
Then within 10 seconds, you're fine.
Right.
And if you're not, you will be fine eventually. Just keep talking.
Yeah.
So we're going to keep talking, but we're going to turn a little abrupt, I realize. Don't have a nifty transition here, but we're going to turn to a case that James has picked out from the Third Circuit. And this involves some pretty heavy stuff. So just warning, if anyone might be shocked by this, or you have children listening, it is about the heavy subject of assisted suicide, which is legal in some states, but not legal in most. And this has to do with the relationship between that and the Constitution's protections on interstate travel and commerce. And it takes us to that great state of New Jersey. So,
but before we get heavy, I would just like to extend my condolences to the children whose parents apparently make them listen to Short Circuit. That sounds awful.
I have heard of such instances over the years, and we have a proud child community. There are dozens of them, I'm sure, who listen to this show in the back seat. But this is yes, a one that maybe some children would not quite be appropriate for. But James, tell us about this interesting dilemma and in conflicts of issues in New Jersey.
So this is a case called Bryman versus Murphy. And in this case, the court decided whether New Jersey's residency requirement for physician-assisted suicide, also known as aid in dying, was constitutional. And the plaintiffs in this case were two patients from out of state, one from Delaware and one from Pennsylvania, and two doctors from New Jersey. And they brought a challenge against the residency requirement of the physician-assisted suicide law under three prongs of the Constitution: the Privileges and Immunities Clause, not the Privileges or Immunities Clause, which we can get into in a minute, the Equal Protection Clause, and the Dormant Commerce Clause, to the extent such a thing exists, which is, again, a longstanding question. Actually, procedurally, there was an interesting question of whether there was standing in this case. One sort of unfortunate circumstance of how the case developed was that these are terminally ill patients, and both of them died before the case was decided. One was decided before the appeal and the other after oral argument. One of the doctors, in the meantime, had retired during the litigation, so that left one doctor left to continue the challenge. And there was some discussion below and at oral argument as the extent to which the case might have been moot. Raised some interesting questions there, which we can get into, but the short of it was that the Third Circuit was willing to say that there was both first person standing on behalf of the doctor and third party standing, which sometimes you can assert if your interests are sufficiently close. So that wound up being a little bit of a non-issue. So the interesting part and the meat of this case was about the Privileges and Immunities Clause. So there are two privileges with immunities clauses in the Constitution. One's in Article 4 that applies to the states, and the other is in the 14th Amendment. That's not the one that's at issue here, although obviously that's a clause that's of great interest to IJ over a long term. And IJ's also had this long relationship with the Privileges and Immunities Clause too. It essentially prevents states from discriminating against people from other states or businesses.
We've done a handful of privileges and immunities, I think, over the years. Bob, have you done one of those?
I don't think I've done it personally, but we've definitely, the nice thing about the Privileges and Immunities Clause is it's one of the few parts of the Constitution the Supreme Court has recognized explicitly protects economic rights. It protects your right to earn a living. It protects your right to, obtain whatever license is needed to earn a living and prevent states from discriminating against outsiders. So it doesn't come up all that often, but we are big fans.
Yes.
Yeah, and the Supreme Court has recognized certain basic rights associated with, just as Bob said, there's some economic liberty rights, the right to ply your trade, to own and transfer property, court access, voting, that sort of thing. So in other words, if you go to another state or if a state treats you differently, then it could raise a privileges and immunities question. And here, the privileges and immunities question issue was the right to travel. And the Supreme Court has basically recognized three things that the privileges and immunities entitles you to do when traveling to other states. That's to exit and enter the state, and to live as a resident, to be welcomed as a new resident. But the plaintiffs here rested their case on the second prong of that kind of test, which is to be treated as a, quote, welcome visitor. So if you travel to another state, you may not have all the rights that a resident of the state has, but you have most of the privileges and the sort of core bundle of rights that you could have. And what the plaintiffs here contended was that they had the right to travel to another state and get general medical care. And one of the big questions that was largely avoided in this case was whether such a right to go and get general medical care exists or not. And we can talk about this in a bit, but I think that's sort of the looming large question that this case helpfully sidestepped, because with the advent of telehealth, there's probably a lot of good reasons why people should be able to get access to doctors across state lines and to travel across state lines to get access. And I think some of those cases are beginning to bubble up. But the court here basically said, you know what, we're not sure there's a right to travel to go get general Medicare, but we're going to decide this case as though there is, so that we don't have to deal with that problem. And what the court held was that there was no such right to travel to get, I'm sorry, that there was no infringement on the privilege of traveling to another state to get general Medicare just based on the suicide law. And the reason was that the law was essentially geared towards protecting New Jersey's own doctors, New Jersey's own patients, into avoiding friction with the states. So there are 35 or more states where aid in dying is still a crime, and any doctor who could provide the medication needed to assist in suicide, if they dispense the medication and you go across state lines and you do it in a state where it's illegal, that doctor could potentially face prosecution. And so the New Jersey law essentially shields New Jersey licensed doctors from that kind of problem. And at the same time, it gives New Jersey residents the ability to avail themselves of something that's traditionally within the sphere of state regulation, which is in medical care. And then, as the court said, it avoids this problem of upsetting the balance between different state interests in this morality legislation. So one kind of interesting hidden feature of all this is that one of the cases that the plaintiff relied on was Doe versus Bolton. And Doe versus Bolton was a companion case to Roe versus Wade. It was decided the same day at the same time. And the case kind of suggests that you do have a right to travel across state lines to get general medical care. I mean, this is the court in that case said, here I'm quoting, "A contrary holding would mean that a state could limit to its own residents the general medical care available within its borders. This we could not approve. So if there were a residency requirement, then state could be limited to people within its own borders." And the Supreme Court said, no, can't do that. However, as the Third Circuit pointed out, it's not clear that Doe versus Bolton survives after Roe versus Wade was overturned in Dobbs. But even so, there was no out-of-state plaintiff in that case, and so this is probably just dicta. But again, the Third Circuit said, well, even if Doe versus Bolton survives, we find that the means to satisfy this legitimate state interest has been satisfied. So that was the nub of the case. The Equal Protection and
Dormant Commerce
Clause. That's what it's called. The Dormant Commerce. I'm an actor. The Dormant Commerce Clause lines of argument were essentially rejected after that. The Equal Protection Clause requires that you be able to assert a fundamental right. The Supreme Court long ago held in 1997 under Washington versus Glucksberg that there is no fundamental right to physician-assisted suicide. And so rational basis applies, and as we know, rational basis is no scrutiny at all. And so the New Jersey law survives as a result of that. And the Dormant Commerce Clause analysis was also dispensed with fairly quickly. The court said, this is essentially for commercial, laws that unnecessarily burden interstate commerce and economic activity, commercial activity. This is not primarily that kind of legislation. It's morality legislation dealing with health and welfare, and so we're not, even if we're not going to apply it. But again, even if it applies, it satisfies the means and tests. So the decision was fairly brief, but as I say, I feel like there's an elephant in these mouse holes somewhere. There is some larger question of the right to access medical care, and I think, as I say, some of these cases may be burbling up, and we'll see more of this kind of thing.
Lots that can be said about this case. I'm curious what Bob wants to draw out of it.
No, I mean, it's definitely an interesting opinion. And I mean, at kind of the top level, the panel's application of scrutiny, I think, is really compelling, right? Like, the only form of assisted suicide that's legal in New Jersey is prescribing pills that help people end their lives. And if a New Jersey doctor prescribes pills to someone who takes them home to Pennsylvania, takes them and dies, like, you can envision real difficulties ensuing from that. So I understand the scrutiny analysis. I was surprised by how skeptical the panel was of the existence of an underlying right. Like, yes, the line in Doe v. Bolton is dicta, but the panel also seems skeptical that you can kind of draw these rights at that level of generality, that you could even say you have a right to seek medical treatment rather than have to have a narrower right to seek assisted suicide, which strikes me as wrong. Like, that's not how we usually talk about fundamental rights under the Privileges and Immunities Clause, where, we just say it's your right to pursue a common occupation. It doesn't have to be your right to pursue this very specific narrow occupation you're trying to pursue. I have not done the historical analysis of your right to seek medical care, but I would not be surprised if there is some originalist evidence there. And I have to think that if these were different facts, right? If this were a state that had access to a cache of a life-saving vaccine or something and wanted to say, no, the only lives we're going to save are New Jersey lives, and you can't drive from Pennsylvania and get the life-saving vaccine. The panel opinion here seems to suggest that that would be A-okay. And that, again, not an expert, I don't know, but that strikes me as a surprising result.
Although that does remind me, I hadn't thought of this till now, the Abigail Alliance case that you probably remember, Bob, from the
Well, but
DC
Abigail
Circuit.
Alliance is seeking sort of a substantive due process fundamental right. And in substantive due process fundamental rights, the Supreme Court, for better or worse, has the Glucksberg test that says you have to define the right really narrowly and then do a historical investigation of whether you have that really narrow right. But that's actually not what we do under the Article 4 Privileges and Immunities Clause. We do have these broader sort of what we call the Corfield v. Corio list of rights, which are broader natural rights that the court has recognized in this context. That I don't think that's a correct move. I think you can define it more generally. I don't know exactly how generally, but more generally than you can in sort of the Abigail Alliance context. And once you do that, I would be surprised if there's not, a long-standing historical tradition of strangers being able to call upon physicians for aid.
I mean, it happens all the time. I live in Minnesota. People come to the Mayo Clinic in Rochester here all the time because that's the place where you go for these special cancer treatments or what have you.
Yeah, one phrase that came out in an oral argument was death tourism. That was something that apparently was one of the state interests that the court was interested in not promoting. But
which
to
I
me,
learned from the appendix of the opinion is legal in Vermont. It is the one state in the country that doesn't have a residency requirement for its assisted suicide law.
Yes. To me, the kind of nub of the question is the problem of protecting health, safety, and welfare, right? I mean, that's a traditional state interest. It can be a dual-edged sword. On the one hand, it's true, states have an interest in protecting the health and welfare of their citizens. On the other, health and welfare is often a sort of, but for the children kind of pretense for other kinds of activity that is more protectionist in nature or that inhibits the right of people to obtain something that doesn't hurt other people. And the buckets that I think of this case in is one in which what states really want to prevent is permitting something that would be illegal or criminal somewhere else or highly regulated. So, for instance, if the doctors were prescribing marijuana in the days when marijuana wasn't available everywhere, or there are controlled substances that they could prescribe, that might be difficult to obtain from one jurisdiction to the next, or where there's no federal rule about it. Those kinds of things sort of make sense. But if you think of your bulk of workaday cases where you just want to be able to talk to a doctor about something or another, you wonder why you don't have the right to do that. So there's no bright line in the difference between those things, but I think that we may be careening towards discovering one.
No, and I think that's sort of the panel opinion here, probably to most lawyers uncontroversial in outcome, but it does say a lot of stuff about the scope of your right to get medical care as an out-of-stater that is certainly going to be cited against plaintiffs in cases that have very radically different and more sympathetic facts.
Absolutely. Yeah. And one last thing I'll say about this case, I was struck by the lack of a scrutiny tiering, right? So they talk about, I think, with equal protection, like you said, James, but you could see where the court's saying, okay, this is a fundamental right, but it's overcome in this case because the state just has such a compelling interest on not having these doctors be prosecuted by out of state AGs or what have you. And it's a reminder in the dormant commerce analysis doesn't have much of a scrutiny discussion, which is a reminder to me of how messed up dormant commerce clause law is these days in light of some recent Supreme Court cases where it's hard, unless you have an absolutely explicitly protectionist regime, it is really hard to know how to do that area of law now.
Yeah, though in fairness, I do think that's what the panels do. Like they say all this bad stuff about the scope of your rights, but then they say, well, let's assume you do have a fundamental right to receive medical care under Article 4. This still survives scrutiny. We don't call it strict scrutiny in the Article 4 bucket because it's just this bizarro constitutional land where none of the doctrines you're used to apply.
Mm-hmm.
But instead of being tiered scrutiny, it's just kind of an on-off switch. And so you don't have tiers of scrutiny. You just have the tailoring scrutiny you do under the Privileges and Immunities Clause, which kind of looks like strict scrutiny, but doesn't have that name and is maybe different in certain ways.
It does seem like this legislation was carefully thought out. I didn't dig too deeply in it, but like a lot of aid in dying laws, it has very strict requirements. You have to provide an oral statement that you want to do this, then a written statement, then another oral statement. The doctor has to be able to verify that you actually have a 6-month, terminal diagnosis. You have to be adjudged mentally competent. So there are a lot of things that go into it that make it seem like the legislature was paying attention and took all of these considerations into, factored them all in when it enacted this law.
Right.
So I think, so subtly the subtext of all this is, what else are we supposed to do? And, this is a fair way to kind of thread carefully through this fraught area of moral legislation. And so I agree with you, Anthony. I think most lawyers would probably agree, this is the most likely way for this case to have come out.
Well, it turns out that an area of law that is not carefully thought through, perhaps, is federal extortion law. And we're going to be moving to that in just a moment. But first, I must put in a plug for a great opportunity if you are a law student. So if you are currently a law student, the portal is now open for applying to be a Dave Kennedy Summer Fellow at the Institute for Justice. This is your chance to be a law clerk for us for the summer. The applications will be reviewed well into January, but earlier is always better. So if you are a law student on break right now, in your holiday break, you're interested in working for IJ, feel free to check us out. We'll put a link in the show notes, but also you can just check us out at the website to apply. Both Bob and I are former summer clerks at IJ, and somehow we ended up working here also. So let that be a lesson. So Bob, one path that you did not follow in life, however, is extorting your employer after you've quit. So tell us about what happened to these women, and somehow they're not going to jail.
Yeah, or at least one of them is not. I don't know what happened to the second one.
The other one.
But I will second Anthony's recommendation of IJ's summer program. In addition to spending a lot of time in off-Broadway theater, the best thing I did in law school was interning at IJ. It changed my life. It can change yours. But that brings us to United States v. Eddings, a case coincidentally decided by exactly the same panel that decided James's case, which had a heavy week this week. And what happened here is a Pennsylvania woman was hired to do some consulting for a nonprofit group organizing an event. And as part of organizing the event, the nonprofit gave her a link on her home computer that let her access the email account of one of the board members. So she could send emails to invitees and sort of organize this event in his name. She lasted in that job for, I believe, exactly 1 week. She thought she had been hired full-time. The company thought she'd been hired as a contractor for this one event. things went south, and she ends up resigning a week after she's hired, and sends an email sort of resigning and demanding that she be paid several $1,000s for the work she's already done this week, which maybe is a fair hourly rate, maybe is not. And the nonprofit ghosts her. They don't give her thousands of dollars. And she goes to a friend of hers, Frances Eddings, from the caption of this case. And her friend concocts this scheme where she still has a link on her computer that will allow her to access this nonprofit board member's email address. And so maybe a month later, they go in and start downloading stuff. The opinion does not tell us what stuff they found, but they get internal emails and financial documents, and after gathering all of this confidential information, they go back to the nonprofit and say, if you don't settle up this lost wages claim, which now is worth six figures instead of a few $1,000s, we're going to go public with whatever it is we found that apparently the public will care about this nonprofit foundation. And as is wise, instead of paying them six figures, the nonprofit calls the FBI. And the FBI charges them with, not with extortion, which I guess we can talk about, but with violating the Computer Fraud and Abuse Act of 1986. And the fact that the law has computer in the title and 1986 is the date should tell you it's going to be a mess. And it is. So the Computer Fraud and Abuse Act makes it a crime to get information off of a computer that is connected to interstate commerce without authorization. In 1986, not every computer was connected to interstate commerce, but now there's the internet. So this is a regulation of every computer, cell phone in the United States of America, and it criminalizes accessing it without authorization. And so to make explicit what's kind of happening in the background of all of these cases, that's an insane rule, right? Like, if you read the text for what it says, every time you use a computer and violate the terms of service you did not read when you downloaded that app or that service, you are committing a federal crime. And that just cannot be. And so courts try to find ways to read this statute in a way that does not make every American a felon. And this case kind of raises yet another instance of that, right? Where the woman had a link on her computer. She had sort of access to the computer, but she had access as part of her employment, and she had resigned her employment. And the question is, when you quit your job, does that mean that you have also lost authorization to access your employer's computer? And the majority says no. Obviously, it doesn't. The authorization to access the computer has to come from the nonprofit. They initially gave her authorization, and then, as far as the record shows, they didn't do anything after she resigned. It's not like she had a contract that said you can only access this computer while you're employed. It's not like they sent her an email saying you're not allowed to access our computers anymore now that you've quit. And they didn't turn off her link until after she sent her wildly extortionate demand, at which point they kind of realized that they had made a whoopsie. And for the majority, that's just the end of it. That authorization comes from the computer's owner, and resigning comes from the employee. And that means definitionally, the employee's act of resigning cannot be enough to revoke the authorization. The employer has to do something in response. And the dissent, not unreasonably, says, come on. we all know when you quit your job, that means you're not authorized to access your employer's computers anymore. That's what quitting your job means. And we can all think of, and the dissent has sort of very practical examples of, you give your email password to a girlfriend so that she can send out a party invitation, and you break up, and 3 years later she uses your email password. You don't need to have told her not to do that in the breakup conversation. Which, and so the dissent's point is not that this dispositively means she didn't have authorization. That seems like a fact question. And so this is one of those cases that the facts are wild. You read the facts and these people definitely did something wrong. But it's also something where the majority opinion does kind of go to great lengths to lay out these policy implications of the broad reading of this statute. But also on a forward-looking basis, the things the majority is pointing to are like, well, if it was in the fine print of her employment contract that she wasn't allowed to access this anymore after she resigned, well, then it would be a different case. And so it still seems, for all that I understand and I kind of sympathize with the need to find a way to read this 1986 statute narrowly, lest it destroy the internet, which Congress did not know about in 1986. The actual path the majority takes seems like it has all of these traps for the unwary, that if we're going to say it's unjust to punish Ms. Eddings, it's odd to then say it's perfectly fine to punish someone who does exactly what she did, as long as on page 17 of someone's employment agreement, it said something about not accessing the computers after you quit. So
I can hear HR
HR
consultants everywhere typing that out into their boilerplate.
Oh, exactly. It's just going to be in like the auto response for everyone now. So I'm not sure as a practical matter this makes that much of a difference in narrowing the statute, but it does certainly for Ms. Eddings. It makes a big difference because she is now no longer a convicted felon.
James, your thoughts? Have you ever been in a bit of a pickle like this?
Not personally, but this does put me in mind of one of my college economics classes where the professor once told us why you should always escort somebody off the premises when you fire them and give them 2 weeks pay instead of giving them 2 weeks notice, because it involved a baker in Buffalo who was the icer, the guy who wrote the nice greetings on the cakes. And they gave him 2 weeks notice. And on his last day, he wrote blank you on every single cake that went out the door. So this is a good reminder to just button up your termination procedures when you let somebody go. So
he had authorized access to those cakes.
He did have authorized access. That's right. The Bakery Act of 1967 or whatever it was narrowly construed. So I guess there are two ways to look at this case. One is, as Bob suggested, hooray for the rule of lenity, right? We want to construe criminal statutes narrowly. It's good for employees. It puts the burden on the party more suited to resolving these issues, like the employer. The other way to look at it is it's another decision, sort of favoring over-papering and over-regulation of employment relationships when everybody obviously knows that if you're let go, this sort of all you're really doing is favoring large employers who have the HR departments to be able to enact this stuff, and nonprofits like the one in this case or small businesses are forever going to be struggling to catch up with these sorts of micro rules. But in the interests of thinking that there are hard cases make bad law, I'm kind of hoping that this is just one of those where it's sort of an edge case, and most cases will not require this sort of formalism in interpretation.
It's also a follow-up. The court cites it a lot on another recent case called NRA Group, which is not that NRA, a different NRA that we talked about on the podcast just a few episodes ago. And that one, there were much more sympathetic plaintiffs who, or defendants, I should say, who basically were being accused of violating the statute as retaliation for filing sexual harassment claims on a pretty unruly employer, it sounded like. And so you can see how this statute kind of swings from one wild application to another.
Well, and you can understand, that's why I think courts are so motivated to read it narrowly, because if you just read it in pure isolation, the link you sent me inviting me to this podcast recording said it was going to last an hour. And so there's a sense in which on minute 61, I will have exceeded your authorization to access your recording app and will be committing a crime. And just that cannot be. And so we have to find ways to explain why that is not acting without authorization. But again, part of the problem is that all of this falls under a 1986 law about computer hacking that does not necessarily map well onto the modern information age.
I'd like to know what the real story behind this is. This has a little bit of the whiff of prosecuting Al Capone for tax evasion. Like, there's a federal prosecutor to come after, six figures, but sort of small, and under this computer fraud statute, you sort of wonder, was there something else going on here that they just really wanted to nail these people for?
I mean, I really want to know what they found. Like, that's the thing that no one meant. Like, what did they find on this like cancer nonprofit board member's email account that they thought was worth six figures? Which, like, obviously the opinion does not say, because that would mean the extortion worked. But it's it's the dog that didn't bark here, right? Like, there must be something going on.
That's right. Tune in next week to find out on Adventures of Computer.
Well, if any listeners know, we'd love to hear. So you can find our emails online, and maybe Short Circuit can be part of the story here.
Soliciting leaks about this case.
but we will leave it here for now. Not do any more acting about what may have been going on. But I would like to thank our actors, our master thespians, for a little bit of a holiday drama and a little bit of Third Circuit action. So, James, thanks so much, and good luck to you at Eimerstall and in your practice. And Bob, thanks as always for joining us on Short Circuit. And thank you, dear listener. And be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.